What's up, Colorado Realtors? I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. So, if you haven't caught the episode I recently did here on inspection termination deadline, then I'd encourage you to check that out. This episode is on another change that was made to the new 2019 contract to buy and sell that I've had a lot of feedback on. Not necessarily questions, but some questions, a lot of feedback. Everybody's got an opinion, as we all know. I'm calling this episode Poor Paragraph 32. Poor Paragraph 32. It used to be the very last paragraph in the entire contract. It was the last statement before the big block at the end of the contract below the signature says, this contract ends here, this is the end of the contract, or whatever it says. Paragraph 32 is just above that, and most of you will recognize it as the countered and rejected line, or countered and rejected boxes. They're deleted, gone, kaput, adios, bye-bye. So feedback I've had has been anywhere from thanks so much for doing that, that's a great change, or we like it so much better, to well, how am I ever going to know now that the listing agent actually presented my offer to the seller? And I am not empathetic to that argument. And I'll tell you why in relation to the Code of Ethics, and maybe a change that I think will help there a little bit. But let me give you a little bit of background. From my perspective, is one of the biggest problems that we were having, and I was getting it probably a couple of times a month on the hotline, particularly with the advent of electronic form contract software and execution. A listing agent would receive an offer, send it over to their seller. Seller maybe not so computer savvy, or certainly not comfortable using e-contract software. And instead of rejecting or countering an offer, which is what the seller was intending to do, they would end up signing it. And then, some software will put it back up in the cloud. It'll automatically distribute it to the other parties as a signed contract, and the buyer's going, woo, we have a contract, and seller's going, no, I didn't mean to sign that. Well, that type of mistaken contract formation is super problematic from a legal standpoint, and probably doesn't always resolve well for a seller in that case, even if it was an honest mistake. But nonetheless, you've got the big nasty lawyers involved, and people are trying to litigate because they didn't accept the right contract, and what a mess. The Forms Committee, in kind of contemplating this, their perspective was, listen, if a buyer or seller or whoever's trying to execute a contract, if they're not trying to execute the contract on that last page, then they really have no business even playing around on that page. And I think that's a really good perspective, and it's a change that I'm very happy to have seen made. The downside to doing that, and well, let me just come back real quickly. There's no point in checking a box to counter. Anything to counter has already been, or any reference or incorporation of terms is already incorporated into the language in the counterproposal document, the preamble of that references the contract offer and incorporates those terms subject to any other changes that a seller or buyer might enumerate in the counterproposal itself. So it was superfluous with regard to the counter box, and the reject box, the seller never had an obligation to check it or read a contract or do anything. Obviously, we all know a listing broker has a uniform duty. They have an affirmative obligation under license law to present every offer to their client. Okay? So that's one way we can assume that a broker is not just being completely irreverent to their license law obligations to present all offers. But now, under the Code of Ethics, the thing I want to point out is under Article 1, there is a brand new standard of practice. The NAR Professional Standards Committee and the full board voted to implement a new standard of practice, or an expansion to one of the existing standards of practice under Article 1 of the Code of Ethics. And what it essentially says is, if you're a listing realtor and a cooperating buyer's broker requests from you after or in connection with presenting an offer, for you as the realtor to provide a written statement or affirmation that, yes, I presented your offer, then you're now, under the Code of Ethics, required to do that. And so that might address some of the concerns that I know that buyers have to say, gee, was my offer presented? And that would just take place with in connection with making the offer or after making the offer, to send an email or something to a listing realtor to say, hey, you received our offer. Please confirm in writing, by responding even just to this email, that yes, I did present your offer to my seller, and they rejected it, or they haven't reviewed it yet, or whatever the case may be. But at least there is that written tangent now to force a realtor to say, I did present your offer in writing. So that helps a little bit. It doesn't necessarily have the seller reject any offers, and it doesn't. The reason I like the change is because it doesn't force the seller or imply that the seller has to do something that they never really had to do before, which was check some silly box that says rejected. So anyhow, paragraph 32 gone. I think it's now probably the first of the broker acknowledgments, but no longer part of the paragraph, and no more countered and deleted boxes. Hope that explains kind of some of the logic behind it and how to potentially address the problem or the perceived problem in the event that you're representing a buyer making an offer. So some events coming up. We've got some classes here that we're doing at CAR. I'm going to do an ACU. If any of you are interested, you can't handle me for more than a few minutes. I can't imagine a 4-hour class with me. But nonetheless, it's available if you want to. And then a water law and contracts class, and I'm going to handle the contract changes portion of that. As well as always, we've got great events and education opportunities at our Spring Summit and our Fall Forum, and the dates are here. You can check those out. Look forward to seeing you at one of those things or hearing from you on the hotline, available 9 to 12 and 1 to 4 Monday through Friday. Hope you guys are having a great winter, a good ski season, and we'll see you on the next episode of Legal Bites.